Hi, everyone, and welcome to Docue Digest, where we break down a particular legal topic into bite sized pieces. On the menu today are disciplinary procedures and how to use the right templates to manage them effectively. I'm Ashley Evans, legal counsel at Docue UK, and joining me today is my colleague Heather.
Hi, I'm Heather, Head of Legal at Docue UK. So Ashley, let's start with the basics. What exactly is a disciplinary procedure?
Great question, Heather. So, a disciplinary procedure is a structured method that businesses use to address workplace issues related to employee performance or behaviour. So it's essentially designed to ensure problems are dealt with fairly and in compliance with employment laws. It helps both employers and employees understand what went wrong and how they can go about fixing it.
That's right. So although they might be conducted slightly differently depending on your business, all disciplinary policies must be fair, and for best practice, they should also follow the general process that's set out in the Acas Code of Practice.
Yes, so the Acas Code of Practice is a really crucial guideline for disciplinary procedures in the UK. Is the Acas Code of Practice legally binding, Heather?
No, but although the code isn't legally binding in itself, employment tribunals will take it into account. They can adjust awards by up to 25% if either party unreasonably fails to comply with the Acas code. So it's important to follow the minimum standards of fairness that the code sets, because if you don't follow it, it can significantly impact the outcome of a case if it goes to tribunal.
Yes, so the Acas Code is definitely something to consider when you're drafting your own disciplinary policy. So let's get into some of the key steps of a disciplinary procedure, shall we?
Absolutely. So the first step is to understand your options after becoming aware of an employee's poor performance or misconduct. Before jumping into a formal disciplinary process, you should ask yourself if the issue can be resolved informally. Sometimes a private discussion or an improvement plan can actually be more effective.
But if that doesn't improve the situation, or if you decide that formal action is necessary, the next step is to follow a fair procedure and inform the employee in writing of the disciplinary procedure commencing and also the upcoming disciplinary meeting, which is known as the disciplinary hearing.
Yes, so it's best practice to put this in writing, and the letter should clearly outline the alleged issue and potential consequences. And the employee should also have enough time to prepare for the disciplinary hearing.
That's right. And don't forget, before the hearing, you should also conduct a thorough investigation relating to the disciplinary. So, this can involve gathering all the relevant facts and evidence, and if necessary, speaking to any relevant parties. This step really is crucial to ensure you have a full understanding of the situation before you conduct the disciplinary hearing.
Once the investigation is complete, you'll move on to a disciplinary hearing. Here, both the employer and the employee will present their sides of the story. The employee can bring evidence, ask questions, and legally the employee has the right to invite someone, like a colleague or a union representative, to accompany them to the hearing.
Yes. And then after the hearing, it's time to decide on the disciplinary outcome. So, this could range from no action to a verbal or written warning, or even dismissal in severe cases, such as cases of gross misconduct. It's important to be fair, and if you've already handled disciplinaries of this kind in your business, it's really important to be consistent with how similar cases were handled in the past.
If a written warning is the outcome, make sure your written warning letter includes all of the necessary information. Even after the disciplinary procedure ends, there are still important steps to take. You should communicate the outcome to the employee effectively while maintaining confidentiality, and you should also keep records of all disciplinary cases. If for whatever reason the decision is dismissal, it's crucial to handle the situation with care.
Yes, the ACAS website says that dismissal is more likely to happen due to an employee's gross misconduct or repeated issues despite prior warnings. So do keep this in mind when you're making your decision. Also, don't forget that employees have the right to appeal decisions that they feel are unfair. Plus, all records must comply with data protection laws, meaning they should be kept confidential and only for as long as necessary.
Absolutely. And is there an easy way to help you create your own disciplinary policy or a written record of a disciplinary procedure that complies with the law?
Yes, for those who need a little bit of help when it comes to their disciplinary process, Docue offers a range of customizable disciplinary templates, including a disciplinary policy and the disciplinary letters we've mentioned today to streamline the process and ensure you're compliant with UK laws.
That's right. So whether it's a disciplinary policy, disciplinary invitation letter, written warning, or a dismissal letter, Docue has you covered.
Great. Thanks for listening, everyone.